Cell phones, hey, most of us have them, and do you realize that when you use them, that someone can tell where you were because of where that cell phone accessed a cell tower? And would you like government to know where you are all the time? Well, that takes us to this week's case. Involves some real folks. And basically it was a kidnapping that was being intercepted by the FBI. Long story short on it is that Jay Goldstein, one of the people involved, after a conviction, argued that the information that was obtained from his cell phone provider as to his location was basically not admissible in court because it was protected by the Fourth Amendment. As we all know, the Fourth Amendment provides that people are safe in the privacy of their homes, their papers, from unreasonable search and seizure by government. Okay, and what Jay Goldstein argued through his attorneys was where I was going, what I was doing, hey, that was my own personal business. It was not something that anybody should be aware of, and accordingly, when government got that information by getting my cell phone records, well, that was a violation of my Fourth Amendment. Okay. Well, on the other side of that, the government argued, no, no, no. In this instance, you're arguing that your location, when you're in public, is a matter of privacy. In reality, we know that when people are out in public, they're not private, they're in public. And therefore, you do not have any expectation of privacy. Moreover, there doesn't seem to be any general expectation of privacy when people are going about driving their cars, whether they're going to the store or to a ball game or whatever else, because that's just what people do, and other people see them and they know that they are doing that. On the other side of that was the argument, yeah, okay, fine. Maybe I'm seen out in public, but what I'm doing out in public is not known. You don't know whether I'm going to the store to get a loaf of bread or a can of soup, and you don't know whether I'm really going to the ball game or not. Long story short, when government tried to link my location with the activities that they were accusing me of, that became basically a violation of my privacy, which is protected by the Fourth Amendment. So this case rolled along, went to the Third Circuit Court of Appeals, and there the court had to figure this out. And the court said, you know, this is a very complex and very difficult case because we do have the argument on behalf of government that there isn't any expectation of privacy when you're out in the public. That's the nature of public versus privacy. But in this instance, it was the private cell phone that was being used. Where are we in all of this? And then they looked at some of the cases that went before and looked to a case in 1928, at a time when someone had contended that making a phone call was a private act. And interestingly enough, a case that was decided at that point in time said no, it wasn't. And why did they decide that? They decided a public phone call was a public phone call. Why was it a public phone call? Because there were operators involved. In 1928, telephones were just coming into being. Most people didn't have phones. And when you made a phone call, you reached an operator, told the operator who you wanted. The operator would try and make connection with that person. The operator would listen in on the call, make sure the connection was made, etc. No expectation of privacy. No expectation of privacy. Now, when the technology moved along, more people got telephones, and people would dial up, and then they would get the voice of that individual that they were trying to reach. Other cases then, which were decided later in history, said, yes, there is an expectation of privacy. So now here we are at this time in history where cell phones are out there. Cell phone towers will let people know where those cell phones are located, and is there an expectation of privacy, and more importantly, is there an expectation that that privacy, if it exists, will be protected by the Fourth Amendment? Now these are the two questions that the court had to answer, and the Third Circuit Court of Appeals answered those questions by saying, one, no expectation of privacy when you're out there running around. Two, at this time in history, we don't find that most people view that there is an expectation of privacy. But then most importantly, two, is we find there is no Fourth Amendment protection under something in which there is not an expectation of privacy. Therefore, we find that government, you are right, and yes, this evidence could come in, and yes, in this instance, the prosecutor did, in fact, do the right thing by introducing this evidence. Okay, what do we learn from this? What we learn from this is that technology is ever evolving. And as technology evolves, the law evolves. And at this time in history, we have a situation where we don't have a lot of cases dealing with whether or not those cell phone tower records are going to be available to people as other individuals try and plot where somebody is or was at the time that some certain acts took place. Okay, we bring you this case, we bring you cases every week so you understand how the law works. I'm David Allen.